Welcome once again. This is Professor Guerra Pujol from the University of Central Florida, and welcome again to Legal and Ethical Environment of Business. In the series of videos, we're talking about litigation. So I want to talk about the first part of litigation, which is when a plaintiff, a wronged party, brings a complaint. In this course, I've shown you, for example, the complaint that the Winklevoss twins, along with their business partner Divya Narendra, that they brought against Facebook and Mark Zuckerberg in September of 2004. And that is how a case is initiated, by a complaint. Now, the case can be brought in state court or in federal court, depending on which court has jurisdiction or the ability to, the power to decide the case. We won't go into the technicalities of state versus federal jurisdiction. I just want you to know that we have a dual court system. We have federal courts with each state comprising a district, a federal district. Now, some states like Florida or California, large states, have multiple districts. For example, in California, you have the Southern District, Federal District Court, and you have the Central District and the Northern District, by way of example. Some smaller states, for example, Commonwealth of Massachusetts is a good example, just one district for the entire state. Now, when a plaintiff brings a complaint, the defendant has a couple of options. One option is the defendant is required usually within 20 days or 30 days, if the plaintiff is the government, they must file a response. And that response is called an answer, where they deny any of the allegations of the complaint, or they admit as true the allegations of the complaint, or they aver that they require more information before they can answer the complaint. Now, I will tell you in practice what defendants usually do before they file an answer. They're not required to do this, but as a matter of practice, usually most defendants will submit a motion to dismiss. Well, what that does is that sort of hits the pause button. Now the defendant won't have to answer the complaint until the court resolves the motion to dismiss. Now, there are many reasons why a defendant may submit a motion to dismiss. For example, a common legal argument made to dismiss a complaint is, in fact, lack of jurisdiction. Maybe the defendant wants to argue that the case should be in a different court, or that no court has jurisdiction over the matter. Also, motions to dismiss, the other common ground for filing a motion to dismiss is to simply say, look, even if all the allegations in the complaint are true, and I will tell you that as a matter of law, the court will have to assume that the allegations in the complaint are true. Even if those allegations are true, they fail to state a valid legal claim, which could be then brought to a jury. And here the argument would be, let's take the Connect You lawsuit against Facebook. We saw this in our fourth class session and in our previous discussion assignment, right? One of the major allegations that the Winklevoss twins bring against Mark Zuckerberg is an allegation of breach of contract. Well, in response, and in real life, one can imagine Zuckerberg's attorneys bringing a motion to dismiss, saying, look, this complaint fails to state a valid cause of action here because there is no valid complaint. There is no valid contract. There is no consideration, for example, in that transaction. And so that is a very powerful strategic move because it buys the plaintiff more time. Notice, going back to the Connect You lawsuit against Facebook, there's actually multiple allegations in that complaint and multiple causes of action. We saw, for example, misappropriation of trade secrets or theft, the breach of contract claim, which I just talked about, fraud, among many others. And so if you're the plaintiff, right, you want to take your case to trial, but if you're the defendant, you'd like to get one or more or all of those claims dismissed, right? And that's oftentimes what the defense may do before they even submit an answer to the complaint. And that's very common practice, the motion to dismiss. All right. We've now seen part one of the litigation process, which is when the plaintiff brings a complaint and the defendant either files a motion to dismiss or an answer. Now, even with a motion to dismiss, if that motion to dismiss is denied in part, then of course the defendant will then file its answer. This stage is usually called the pleading stage. In my next video, I'll talk about the second part of the litigation process, and that is discovery. Thank you for your attention and have a good day. Go Knights.